Divorce court in Florida is incredibly unique. Unlike other states, Florida is a no-fault divorce state, meaning that you do not have to have a specific defined reason for getting a divorce. You simply want to have a divorce. Of course, the reasons may be relevant, and the judge or opposing counsel, if this is a contested case, may probe those reasons. But you do not have to allege a reason with specificity, as you would for other causes of action. And divorce is a process, as you may have heard us explain in other videos. It starts with your pleadings, your petition for dissolution of marriage, and related documents, which may include a notice of social security number for vital statistics records. It may include, if you are parents, a parenting plan proposal, a uniform child custody jurisdiction and enforcement act form, specifying where the kids have lived, with whom and when, for what periods of time, and at what addresses, among other documents. Once the initial pleadings are made, if this is a contested case, the other side has 20 days to respond from the day that they are served with process, which is a requirement. The court must have personal jurisdiction over the parties and subject matter jurisdiction over the parties and any minor children. And that, of course, means that your kids must have lived in the state of Florida for at least 6 months before the date you have filed your petition. Not 5 months and change, but a minimum of 6 months. Be very, very careful in how you proceed and when you file, because the date of filing is important, and it establishes a record for certain jurisdictional purposes, among other purposes, including equitable distribution of marital assets and liabilities. Once that occurs, you will then engage in the discovery process, in which financial documents are exchanged. And as of late 2020 and early 2021, the amount of mandatory disclosures that you are required as a litigant in a family law case to exchange are quite voluminous. They are now more substantial and go back as far as 1 year or 2 years, with a backward look to determine each party's true assets, true liabilities, and true incomes. Ultimately, your case will undergo a family law mediation. If the mediation is successful, all that may remain is to finalize some outstanding issues or to finalize the case altogether. If mediation is unsuccessful, what follows may be interrogatories, requests for admissions, depositions, or perhaps a family law trial, in which all issues in your case will be decided by the court upon the hearing of evidence, the admission of exhibits, the testimony from the parties, and any witnesses they decide may have pertinent, relevant information that is not objectionable. Ultimately, divorce can take as few as a few months, or as little as a few months rather, or as long as a period of many months or even a couple of years, depending on the number of issues, how contested your case is, how many motions are filed, and the extent of the discovery. That is, in a nutshell, divorce court in the state of Florida.